Hi everyone, today we will be looking at another chapter in Conflicts of Law, which is Forum Non-Conveniences. So, as I mentioned earlier in our previous videos, Conflicts of Law deals with disputes which have an international element. When questions such as which law should be applied, which court has a jurisdiction to deal with the situation, and all of that's talked about. So, we did talk about the jurisdiction aspect in jurisdiction in personam, which was the previous video with regard to conflicts of laws. And today we'll be dealing with another principle, which is forum non-conveniences. So very simply put, a dispute can only be heard under suitable court or forum. And as I mentioned in the jurisdiction in personam video, that is the only way a dispute can be heard of. However, there are situations where the dispute is taken to a different court, when there is a more suitable and appropriate court available. And that's the situation that deals with forum non-conveniences. So very simply, if you break down the concept of forum non-conveniences, non-convenience means it's not convenient enough for a court to carry out a dispute. Therefore, another aspect comes into play stating the dispute must be convenient enough for the courts to be carried out. So, it was seen in the Antares case, it was held that the state will not exercise jurisdiction if it's seriously inconvenient for that forum for a trial of that nature to be carried out, and that a more appropriate court is available to the plaintiff. So this very blatantly states the reasons why some courts cannot carry out jurisdiction over certain matters and disputes. So a court may refuse to do so by issuing an injunction or stay order. It's important to mention that injunctions and stay orders are not issued against the courts. They are issued against the parties, as it was seen in cases such as the Amin Rashid versus Kuwait Insurance Company case, where the English court issued an injunction stating the courts in Kuwait are not the most appropriate forum for the dispute to be taken forward, and that this was due to the contract being in English law. We'll be looking into the Amin Rashid Shipping Company and Kuwait Insurance Company case because it's a very important case in the conflicts of law, and we'll be discussing it thoroughly as we progress forward. Another such case is the Lee Kuan Juk versus Social National case, which dealt with a helicopter crash, where proceedings were brought forward both in the United States as well as Brunei. However, proceedings were first taken up in the United States, and then the Privy Council issued an injunction stating that the most appropriate forum for this kind of dispute is Brunei, because the accident happened in Brunei and it dealt with a citizen of Brunei itself. So let me define what a stay order is. A stay order is an act that temporarily stops judicial proceedings by an order of another court. So only a court can issue a stay order against another court. And then when we talk about issuing stay orders, the hierarchy of courts comes into play as well. So, forum non-convenience is really a principle and a doctrine which we need to analyze thoroughly. And it can be done by looking at various cases, important cases. So, English courts rarely discontinue proceedings once a claim is served within a jurisdiction of a country. So let's start with what the most important case that dealt with forum non-conveniences, which is St. Pierre versus South American Stores. In this case, it was held that mere balance of convenience is not sufficient to get the advantage of prosecuting the action in England. To justify a stay order, the following conditions must be satisfied. These two conditions are supposed to be the key and the landmark or the standard for a stay order to be maintained. The defendant must satisfy the court that continuing the action would do an injustice. And finally, the stay must not cause an injustice to the claimant. So in such situations, it's quite clear why stay orders are needed. If these can be proved, a stay order will be granted. If not, they will not be. The burden of proof of proving those conditions is with the defendant. And especially in the English court system, which deals with conflicts of laws, the concept of legal Chaoism is given much priority. Chaoism basically means adhering to orders and such like that. Therefore, it states that no one should not be denied the law should not be denied to litigants of foreign courts. So, as I mentioned earlier, St. Pierre versus South American Goods Store was the landmark case. However, as time proceeded and more disputes arose, there were different cases which made very minor but effective impact on the way the legal world looks at forum nonconveniences. So these cases are also important. The Atlantic Star case, firstly, the Lord Denning says that the right to come here are not confined to Englishmen, but extended to friendly foreigners as well. If you remember, just the case I stated earlier, which is St. Pierre versus South American Goods Store, that deals with a case carried out in England, and it only had both parties. One party was English, and that was supposed to be the reason why forum nonconvenience was called forward. However, in the Atlantic Star case, Lord Diplock clearly states that it's open to all friendly foreigners. Let me remind you, when we talk about friendly foreigners in that era, we're mainly talking about Europeans and Americans, nothing more. However, as the law progressed and as the time went on, it's open for anyone, and that's why we're learning conflicts of law today. The second important case is Mack Shannon versus Rocawear. Again, Lord Diplock played a key role in this as well. As he stated, two conditions must be satisfied to justify a stay, which is quite similar, but with minor yet effective changes to the conditions given in the St. Pierre vs. South American Goods case. And these conditions were: the defendant must establish that another forum is better, less expensive, and less inconvenient. So the second being, the claimant must establish that a stay in English courts must not deprive his judicial advantage, which will be available to him if he invoked the English court. So this is both a win-win situation, where the defendant must establish that another forum is more convenient, it's less expensive, it's better than the one in the English courts. However, the claimant has proved the opposite of that, stating if they move this case to another jurisdiction, he will not have the advantage he will obtain when the case is carried out in the English courts itself. So taking all of those into consideration, it's quite the opposites which need to be proved. However, the conditions must be proved by the defendant mainly. Therefore, it's quite difficult to identify what's the actual condition which should be given priority over the other. And then we have the Vivendra case, where Lord Diplock yet again states legal Chavism is replaced by judicial committee. Judicial committee deals with friendship, and if you remember the very first case we talked about, which was the Atlantic Star case, he talks about friendly foreigners. And when we talk about legal Chavism and legal committee means friendship, and therefore he's mainly talking about Europeans and Americans having the ability to carry out disputes in English courts. And finally, the Vivendra case. This is the final case which had a major impact on the landmark case of St. Pierre versus South American Goods Store. So in this case, Lord Joff states that the defendant may apply to the court to exercise his discretion to stay on proceedings. Therefore, the question is not about the convenience, but about the suitability of that court. This is what's applied even at present. As you remember before, what the legal system's only focus was if it was less expensive, if it was more convenient, if it was better. However, they never questioned the suitability of the court. They never questioned which law should be applicable to the dispute. So the Vivendra case brings in that aspect which is much needed, where the legal system will have to consider each and every aspect and look at the suitability of the jurisdiction of the courts which are required to deal with this dispute. So those four cases had a major impact on the landmark case of St. Pierre versus South American Goods Store. And those modifications are present even today in the English legal system. So let me just run a quick summary of the important guidelines taken from the above cases. So number one, a stay will only be granted if the court satisfied there's a more suitable forum. The burden of proof of proving that there's a more appropriate forum is on the defendant. The court must look for factors which point out the existence of more suitable forum, which means the court on its part has to analyze whether there's a different court which has more merit, which is more suitable, which is more appropriate for such a dispute to be heard of. If the court isn't satisfied there's a more suitable forum, a stay will not be granted. In other words, if the court isn't satisfied, stating that there's a better forum to be applied, the case will not be held or stayed or carried out by an injunction, and it will continue in the English courts itself. So let me just give you a quick wrap up of this. So we were talking about non-forum non-conveniences, and basically the word itself states non-convenience, which states courts who cannot carry out a dispute under their own convenience cannot carry out lead legal proceedings over a dispute of such. And let me just run by another quick concept that is required: lis alibi pendens. So we talked about, if you can remember, Social National was a legal joke, which is basically a case regarding a helicopter crash. So in that situation, there's a situation where lis alibi pendens. So lis alibi pendens basically means a lawsuit pending elsewhere. It's a situation where the same dispute is heard by two courts, but the judgments will be inconsistent with each other. This is because mainly there are different rules, procedures to be looked at with regard to different jurisdictions. Therefore, this doctrine of lis alibi pendens states, if the same dispute is heard in two courts, where the claimant is the same in both, generally the first action commenced will be continued. So, as for example, as we took Social National was a legal joke, United States actually carried out the action first. Therefore, according to the doctrine of lis alibi pendens, that order should be the one taken into consideration. However, the Privy Council issues an injunction stating that the United States should halt or stay their proceedings because the most suitable forum is in Brunei. So there are instances where lis alibi pendens is being overruled or overturned. So that is basically the principle of forum non-conveniences. Very simple, very short, easy to remember. The most important part is remembering the history of it, because the concept itself is very simple. It's quite easy to remember, it's quite easy to understand, but the history of it is a bit complex. However, if you understand the cases, if you remember the most important parts of the case, then it will not be that hard for you to remember and write in your exam. And to be quite clear, forum non-conveniences has been an area which has been tested every single time in the paper of conflicts of law for the first year. So I would suggest that you study, put a couple of extra hours on this, get it into your head, and focus on this part as well. So today we looked at forum non-conveniences, and the last video we looked at jurisdiction in personam. So quite clearly we already distinguished the jurisdiction, which law should be applied to certain persons and individuals of a dispute, and now we looked at the reasons why a court will not have jurisdiction over a particular person. So on the next video we will be focusing on different aspects of law, such as contract law, delict law, family law, and the laws that should be applied in such a scenarios where it's not dealing with any commercial or international aspects. So that's all for today. Hope you guys learned something. It's quite easy remembering this part, but then again, history is what needs to be clarified right here. So hope you guys are staying safe, and hoping to meet you guys soon. Have a great day.